Hello everybody, welcome to EPG Pathshala. We are now looking at the course Constitution of India and Affirmative Action for Women in the course Gender and Social Work. I'm Monica Sakrani. I'll be taking you through some of the provisions of Constitution of India and what does affirmative action mean. Then we'll be looking at affirmative action for women through cases decided by the Supreme Court of India, and we'll be looking at some of the important judgments. So we first look at the Constitution. The Constitution has 395 articles, 22 parts and 12 schedules. There have been overall till 2016 September 101 amendments to the Constitution. And so basically amendments to the Constitution mean that our Constitution is quite a flexible Constitution, it's not a rigid Constitution. Our Constitution has unitary system with federal features such as because it provides more power to the central or union government as against state governments, and also the residuary powers, that means anything that is not there in the 7th schedule which lists out different state, center and or the union, and the concurrent list has the provision that anything that is not listed over there will lie with the central government. And if we look at the list itself, the central government has far more powers and the more important powers than the state government does. As I said, that the Constitution has been amended several times, 101 times till September 2016. So how much can the amendment affect the Constitution? Can you amend the entire Constitution is the question, or to what extent can you amend the Constitution? So this question kept coming up before the Supreme Court, and in 1993, in the case Keshavananda Bharati versus State of Kerala, the Supreme Court said that any part of the Constitution may be amended, but it should not distort the basic structure of the Constitution. So this whole doctrine of basic structure was introduced. Now, over the years, in several judgments, the Supreme Court has held in various cases whether an amendment distorts the basic structure or not. So there are many aspects to the Constitution that the Supreme Court over the years has held that they cannot be changed. Now, what are these elements of the Constitution that cannot be changed, or what is the basic structure? So what has been held to be the basic structure is the supremacy of the Constitution, rule of law, principles of separation of powers, objectives in the preamble, right to personal liberty under Article 21, right to equality, right to judicial review, directive principles of state policy, balance between fundamental rights and directive principles, principle of federalism, free and fair elections, parliamentary system of the government, limitation upon amending power of under Article 368, independence of the judiciary, freedom and dignity of the individual, and unity and integrity of the nation, and secularism. So these have been held to be part of the basic structure of the Constitution. Now we look at two important parts of the Constitution which constitute the Bill of Rights for us. These are the fundamental rights and the directive principles. Now the difference between the two, apart from the fact that they are contained in different parts, is that fundamental rights are justiciable while directive principles are not. Now, fundamental rights are mainly individual-centric rights, and within the whole framework of international law of human rights, they would constitute what is known as civil and political rights. So if you want to know more about civil and political rights, you can look at the UN and you can look at the International Covenant of Civil and Political Rights. Whereas the directive principles are mainly group rights or community rights, and they are economic, social and cultural rights. So these, again, if you want to look at what is economic, social and cultural rights in greater depth, you can look at the International Covenant of Economic, Social and Cultural Rights. Now the Supreme Court over the years has tried to erase this distinction between civil and political rights or fundamental rights and directive principles of state policy by saying that directive principles have to be read into fundamental rights and they have to be interpreted harmoniously. Like my right to life would include my right not to starve, my right to food. So you can't say that you have a right to life but you don't have a right to food, you have a right to life but you don't have a right to health, which falls under the directive principle. So sorry, we cannot give you this right. So this is how the Supreme Court has held. So right to health, right to food have all been interpreted as right to life under Article 21 of the Constitution. So that there is no apparent inconsistency, and basically the goal is that people should get their rights. Now, what is the difference between justiciable and non-justiciable? Any law which violates the fundamental right can be struck down under Article 32 and 226 by the High Courts as being unconstitutional. Law is to be broadly interpreted. Now, what is law is that does it mean only an act of the Parliament, or does it mean any state action? So the courts have held that any state action. Article 12 and 13 also broadly interpret law and state to include any state action, and state to include any of the instrumentalities of the state. So if a policeman is refusing to release a person or has kept a person in illegal custody, that would amount to state action, and his act of not releasing the person would amount to illegal act. So that would be struck down. So any act of the Parliament also would be covered, but any act of any instrumentality of the state would also be covered as law. And if you want to challenge any law as being unconstitutional or as being violative of your fundamental rights, then you challenge it by filing a writ petition in the High Court or in the Supreme Court. In the High Court, you file it under Article 226 of the Constitution, and in the Supreme Court, you file it under Article 32 of the Constitution. Article 32 of the Constitution is also a fundamental right. Now we come to what are writs. So what is a writ? A writ is an order of the court. It's a written order. Basically, it means that. Now, there are 5 types of writ petitions that can be filed, or 5 types of writs that can be issued by the court. The most fundamental writ is habeas corpus, which literally means produce the body. Habeas corpus is when a person is missing. You file for production of that person. This can be by the state act, like I gave you the example, a person has been arrested by the police and not released, he's in illegal custody, so you can ask for his release. The second is that habeas corpus is the only writ which can be filed even against a private act. All the other writs are filed against state acts or public acts. So habeas corpus can be filed even if a person is, say, held in custody by a family member or kidnapped by somebody. You ask that person to produce the body. So in many cases, habeas corpus are used by husbands who's in love marriages where there is elopement and the girl is brought back by her parents and kept, or an adult girl wants to get married to somebody else, but her family locks her up in a room and does not allow her to meet her boyfriend. So the boyfriend can move the court and say that produce the body. The girl is an adult, she can move anywhere she wants to, and she should be released. Similarly, it's also used in many custody cases by parents who don't allow the other parent. If 2 parents are fighting, one parent has the custody of the child and is not allowing the other parent to meet the child, then the other parent goes to the court and says, produce the child, and I have a right to meet my child, and I should be given the right. So even in these cases, in private cases also, habeas corpus is issued. The other important writ is writ of certiorari. This is if a public servant or a public officer does, or the state does something which is violative of the law, then you get the order quashed or you get the law quashed. A law is passed which is blatantly violative of Article 14. It says that women should not, be given public employment. We'll be looking at some of these kind of laws which were struck down or acts which were struck down. So then those would be, the court would file a writ of, issue a writ of certiorari, quashing the illegal act of the state. The other 2 writs, which are mandamus and prohibition, are direct opposites of each other. In mandamus, the state is refusing to do something, and so you direct the state to carry out its public duty, whereas in prohibition, the state is going to do something illegal, so you direct the state not to do that illegal act. So both are exact opposites of each other. So for example, if you've gone to the police station and the police is refusing to lodge an FIR, then you ask for a writ of mandamus saying that, or there's a policy which is not being implemented, there's a law which is not being implemented. So you file a writ of mandamus asking the state to implement the law. The last bit is quo warranto, which actually talks about the authority of a public servant. So this is if a person is a usurper of office, a public servant who is not qualified to hold office, you ask that person to be evicted from that office through the writ of quo warranto. So in basically these are the 5 writs, but the courts have the power to to pass any order or direction in the interest of justice for the furtherance of our fundamental rights. Now, for the purpose of affirmative action, it is important for us to look at what is right to equality. And because basically affirmative action is to bring about substantive equality. We may all have formal equality, but are we actually substantively equal human beings? And that is what right to equality seeks to address. Right to equality has 2 aspects to it. One is that Article 14, what Article 14 says, everyone is equal before the law and has equal protection of the law within the territory of India. So the state cannot have different laws for different people. Now, the second aspect of this, that is the state cannot discriminate, is held in Article 15, which says that the state shall not discriminate any person against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. The difference between Article 14 and 15 is that the first is couched as a positive right, the second is couched as a negative right. But also that Article 14 says everyone is equal. That means, and the second Article 15 says any citizen. So Article 14 applies to even non-citizens. So we can't have a law which discriminates between citizens and non-citizens. Also, important part of non-discrimination is contained in Article 15.3 for the purposes of gender and Article 16.4, which says that there can be affirmative action. That means you can allow for reservation or special provisions for women and children or other backward classes of citizens. So on the basis of these provisions, affirmative action in order to bring about what is known as substantive equality is allowed. So we just don't believe, our constitution just does not believe in formal equality. It also believes in substantive equality. It seeks to make people equal and not just presumes that people are equal, because if unequals are treated equally, then it actually amounts to discrimination or perpetuates inequality. So that is the philosophy behind the right to equality in our constitution. Now, what is equality according to the Supreme Court? As already said, it means that different classes of persons have to be treated differently, and equality does not mean same or similar treatment. But how do you decide whether differentiation is actually leading to equality or it is not leading to further discrimination? So the courts have held a 2-pronged test. That is, classification of different groups should pass the following 2 tests. One is that the classification must be founded on an intelligible differential which distinguishes those who are grouped together from the others. That means that if I'm having a special law for women and I have a law which, say for example, the sexual harassment law, which says that women can file the case against men. Now, is this based on an intelligible differential, or the rape law, which says a woman can be raped but does not say that it's not a gender neutral law? It doesn't say a man can accuse a woman of rape. Now, is this classification found on an intelligible differential? And yes, because most people who suffer sexual harassment are women, most people who are raped are women. So yes, there is an intelligible differential between those who are grouped together and those who are not. And the second test is that the differential must have a rational relation to the object sought to be achieved under the law under challenge. So if you want to stop sexual violence, then if you have a gender neutral law, will it really lead to sexual reduction in sexual violence, or you need to specifically have a targeted law for that? So these 2 tests, if you're, for example, having reservation for women, so what is the purpose of reservation for women? Will it to promote employment of women? Is there a need to promote employment of women? Is there a need to have special laws for women or not? Will be the justification that the state will have to demonstrate in order to show that the law is actually promoting equality and not leading to further differentiation or discrimination. So the classification has to be reasonable and not arbitrary. Now, what are the other constitutional provisions that are important for affirmative action? Article 21, as I've said, that life and liberty has been expanded to mean a lot of things. So that is used to bring about further affirmative action. Article 39D, which mandates the state to frame law giving equal pay for equal work. This is part of directive principles of state policy. Again, Article 42, which is part of the directive principles of state policy, says there should be maternity benefit. Now, the way in which directive principles are realized is by passing laws. The state is directed to make policy bringing in these kind of changes. So when the state is directed to bring in maternity benefit, it does that through bringing in a law which provides for maternity benefit. So most of the laws which are what the directive principle seeks to do is that the kind of laws that the state should make should be given this kind of framework. So there have been many laws which have been framed keeping in mind the directive principles and the principles of equality, which to promote equality amongst men and women, such as Dowry Prohibition Act, Prevention of Immoral Trafficking Act, Maternity Benefit Act, Equal Remuneration Act, PCPNDT Act, Sexual Harassment Law, and the Protection of Women from Domestic Violence Act. So these are some of the ways in which the state has tried to bring in affirmative action to promote equality between men and women. Now, what are the other ways in which equality has been sought to be promoted? This has been through another tool which is known as public interest litigation. Now, when I told you all about writ petitions, a PIL is a type of writ petition. Now, what happens is that normally when we file a case, you file a case if you are the affected party. A third person cannot go and file a case on your behalf. So that is known as the rule of locus standi, that what is my location? Do I have are my rights being affected? Then I can file a case. But the Supreme Court in the 1970s evolved this tool called public interest litigation, which said that because the court said that there are many people who are so marginalized that they don't even know their rights are violated. They don't know what their rights are, and even if they know what their rights are, they don't have the wherewithal to go to court and get these rights enforced for themselves. So does that mean that they will continue to be unheard by the court? So the court said no, a public spirited person can file a public interest litigation on their behalf and can get their rights enforced. So this is, the court said that this is not, purpose of enforcing the right of one individual, but it is intended to promote and vindicate public interest, which demands that violations of constitutional or legal rights of large number of people who are poor, ignorant, or in a socially or economically disadvantaged position should not go unnoticed and unredressed. So this is the real purpose of PIL. Now, over the years, there have been many judgments with regards to women's rights. Some have come because of individual fights and some have come as a result of PIL. In our e-text, we have looked at many of these judgments in more expansively, but some of the important rulings I will be looking at over here. So the initial first few cases that came about because of exercise by individual women of their rights under different laws which were given to them, or they challenged state action which was discriminatory by filing writ petitions. And these have set a landmark or a benchmark for many of our, the new laws which have come, or the way other generations of women have experienced and enjoyed their rights. So one of the early, historically when we look at it today, we feel, oh, how strange that a woman will lose her job upon marriage. But this was the case in 1966 where it was fought and a rule was struck down. So today we don't have a rule like this. Then in C.B. Muttama's case, there was a rule against, if she's married, then she will not be employed. This rule was struck down. In Maya Devi's case, rule requiring married women to seek husband's permission before seeking public employment was struck down. In Nargish Mirza's case, this was the rule that air hostesses had to be retired or grounded when they got pregnant was struck down. So these are fights that individual women have fought, because of which today we have, we don't encounter situations like this. Similarly, in Audrey DeCosta's case, a stenographer fought for equal pay as a male stenographer was paid, and she got this equal salary. In Anuj Garg's case, the Supreme Court struck down a rule prohibiting women from serving liquor in bars. In Bar Dancers' judgment, it struck down a rule prohibiting women from dancing in bars which served alcohol. More recently, in Charu Khurana's case, the Supreme Court struck down a rule denying women registration as makeup artists in film industry. In the film industry, women could only work as hairdressers and not as makeup artists. Only men could be makeup artists. So this rule was challenged by Charu Khurana, who got an order saying that even women can be makeup artists. Now we come to a very, very important judgment which came about as a result of a public interest litigation. This is Vishakha, or the judgment which laid down sexual harassment at workplace amounted to discrimination against women and gave guidelines for action by all employers on the issue of sexual harassment. The Supreme Court issued guidelines and said that the guidelines would apply till such time as a law would be made. The judgment came in 1997. From 1997 to 2013, when the law came into force, these were in application. After that, the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act has now come into force. So this judgment came about as a PIL which was filed after the Bhamri Devi rape case in Rajasthan, where a Sathin was raped because she was trying to prevent child marriage. So in this case, the court was told that there is no law regarding sexual harassment at workplace, and women are vulnerable to, up to rape, where the woman was raped, to sexual assault because of this. So this parliament has not made any law. So till such time as a parliament made law, the Supreme Court, under the writ of mandamus, issued directions. Another important case is Sheila Barse versus State of Maharashtra, where the Supreme Court upheld the right of women under trials to be kept in separate police lockups and to medical examination. So in this case, it was held that women should not be kept in the same lockup as men, and women, when they interrogated, the interrogation should be in the presence of women police personnel. Another important case was Upendra Bakshi's case. This was again a PIL. Sheila Barse was a PIL. In this case, women who were kept in protection homes, the abysmal conditions in these protection homes were highlighted, and this court gave orders with regards to better living conditions of these women. In another case, Sheila Barse versus State of Union of India, it was a case where mentally ill women were kept in jails. And the court directed that non-criminal lunatics, as the legal term is, should not be kept in jails and should be kept in mental health institutions. So they directed the release of mentally ill women who were kept in jails. In Neela Bhatti Behra versus State of Orissa, the Supreme Court directed that compensation be paid to a mother of a son who was killed in police custody. There are other cases, like in Chandrima Das's case, the Supreme Court directed that compensation should be awarded to women who are rape survivors. In this case, rape was held to be a violation of Article 21, or the right to life of a woman. And they said that if a state actor, in this case the railway police, raped a woman, then the state would be liable for the act of the public servant, and they would have to pay compensation to the rape victim. In an earlier case, Delhi Domestic Workers Forum versus Union of India, the court had issued directions on how the police should handle cases of rape victims. These recommendations, even though these are guidelines and they are not enforced, the Verma Committee report also held that these should be enforced. And it said things like legal aid should be given to rape victims, and medical and counseling facilities should be given to them, and they should have legal representation all through the trial. So from the police station stage till the end of the trial, they should have legal representation. In another case, Geeta Hariharan's case, the Supreme Court held that mothers are also guardians of the children along with fathers. Under the Hindu Guardianship Minority and Guardianship Act, father is the legal guardian of the child, who is a minor child. In this case, the court held that mother also has to be recognized as the legal guardian of a minor child. So now we come to R.D. Upadhyay case. This is a case which was relating to children of women prisoners, and the court held that women prisoners could keep children under the age of 6 in prisons with them if the child had nowhere to go, And it also said that the child who is born in the prison should not be in his birth or her birth certificate, it should not be mentioned that he was or she was born in the prison. Only the name of the district should be mentioned. Children should be given special facilities like special diets, medical examination, and also have creche and nurseries for them. Even for pregnant women, lactating mothers, there should be special diet and medical facilities. And if a child, after the release of the child, when the child is kept away from the mother, is taken after the age of 6, is kept in another place, the mother continues to have a right to meet the child. And when the mother is released, the child also has to be released and given to the mother. So in this module, we first looked at the Constitution, an brief overview of the Constitution. We looked at fundamental rights, directive principles, public interest litigation, writ petitions, and some of the important judgments relating to affirmative action for women. Thank you.